usually some dean type person comes and officially welcomes people. I'm going to do it without a whole lot of pomp and circumstance. I want to thank you for coming. I can't tell you how much it means to me and the program that we've been able to do this for 3 years in a row. When we held our first roundtable, we had no video equipment, no student videos to show you. We held the roundtable so as to drum up a bit of business for student projects. Last year, when we had our second roundtable, we were able to show Shmuel Kaplan, a documentary short that will be shown at this year's Philadelphia Jewish Film Festival. This year, our third year, we have some work to show you, and we have some hope that the program will continue because there seems to be a real interest in visual legal advocacy among the students and among the public interest bar, which continues to supply us with really interesting projects to work on. What is visual legal advocacy? Well, we made it up. It's advocacy or argumentation undertaken by lawyers to advance the interests of their clients and causes, which uses visual media, primarily digital video technology. And I want to show you 3 things today, 3 pieces that I think illustrate the potential of visual legal advocacy. The first is a short film done by Ann Onymous. And I can't say anything more about it than that.
when the judge issued his sentence, he made the point of saying that he was clearly, he was the youngest and was the least culpable involved in the crime, and that, but that he had no choice. You know, that unfortunately he was not able to use any discretion in sentencing, and that he wanted to have that on record, because if there was the opportunity down the line for commutation or any type of change in sentencing, he wanted to make sure that it was on record that that was how he felt, where he was basically saying, I wouldn't have sentenced you to this, but I don't have a choice.
The question that often comes up is, what is the appropriate way to treat juveniles? My name is Bradley Bridge. I'm an attorney from the Defender Association of Philadelphia. I've been attorney here for 25 plus years. I don't think life without parole is a suitable punishment for juveniles for a number of reasons. I think it's kind of a one-size-fits-all phenomena, and that doesn't work for shoes, it doesn't work for pants, it shouldn't work for human beings. So I think that what you need to do is examine the character of the juvenile involved, the type of crime involved, and figure out what would make sense, not today, but 20 or 30 years down the road.
My name is Anita Cologne, and I am the sister of a juvenile lifer, Robert Holbrook. He was very, I guess, happy-go-lucky, normal teenage boy, smart, but also curious. An older drug dealer actually convinced him to come along on what he thought was going to be a simple drug deal, and offered him $500. Turned out to be a robbery of another drug dealer who was incarcerated, and tragically that drug dealer's wife was killed during the incident. My brother had no knowledge that, you know, this was going to happen, and no direct participation. But again, to consent to a drug deal is to consent to a felony, and therefore he was considered as guilty as the person that actually killed her.
You're talking about juveniles who commit a particularly serious crime. And the question is, how can we best treat those juveniles? I think probably the answer is that in some circumstances they should be treated as adults, and in some circumstances they should be treated as juveniles. And really what you need is to have flexibility to deal with that. You need flexibility also in that they should be an opportunity sometime down the road for a juvenile who has changed and is no longer the sort of person who committed a murder and doesn't have that same character anymore, for that to be reflected in their sentence. And if a juvenile is sentenced to a life without parole, there's no opportunity to ever change that sentence, which means if the person changes a lot, and we know that juveniles do change more than adults because they're younger.
In terms of juveniles not being sentenced to life without any possibility of parole, the main reason why they shouldn't be is because they're children. It's been proven academically, clinically, that adolescents' brains are not fully developed, that they're not mature and able to make clear decisions the way adults can. So how then do you hold them responsible and accountable for crimes in the same way that you would as an adult?
Lawrence Steinberg, PhD, Professor of Psychology at Temple University. Lots of people ask at what age the brain is fully developed. And this is a very hard question to answer because different parts of the brain mature along different timetables. But if we're talking about regions of the brain that are involved in, let's say, the coordination of emotion and cognition, or more advanced cognitive abilities, like anticipating the future consequences of a decision that you make today, or impulse control, that those parts of the brain are not mature until early adulthood. And there's some research that indicate that they may not even be mature until the mid to late 20s. If we know that there are certain characteristics of adolescence that make them different from adults in ways that affect their responsibility for their behavior, that their immaturity ought to be taken into account when we make dispositional and sentencing decisions.
You turn around and say that a 12, a 13, a 14, a 16-year-old makes a mistake and they therefore should be suddenly, now when they made that mistake, that they should be as accountable as an adult, that they should have, been able to make that clear decision, when at the same time you're saying you don't trust them to drive, you don't trust them to drink or smoke or do any of these things, but if they commit a crime, then they should be punished the same way that an adult is. And it clearly makes no sense.
If a juvenile is charged with murder, that case automatically starts in adult court. For, 50, 60, 70 plus years, maybe more than that, maybe back to like the 1930s, juveniles have always started in adult court. In fact, I think it probably goes back to the 18th century. There have been a number of suggestions over the years that be changed. To my knowledge, it has not yet been changed, nor has it gotten much traction in being changed. I think there is currently a feeling that that's an inappropriate way to treat all juveniles, to automatically start out in adult court. But I don't know whether any of those particular actions will lead to any fruition. Pennsylvania has probably about 450, when last I looked, juveniles serving life without parole, which puts us far and away the #1 state in the country of juveniles serving life without parole sentences. And there's probably a couple reasons that that's true. First, Pennsylvania has all juveniles charged with a murder automatically start out in adult court. So it doesn't matter how old the kid is. Kid's 10, kid's 11, automatically starts out in adult court. A number of states do not have such a provision. For very young children, those kids are automatically kept in juvenile court, or the cases start out in juvenile court and there might be discretion to send the case to adult court, but not in Pennsylvania. So Pennsylvania automatically starts out all homicide cases in adult court. The second reason that there's so many juvenile lifers in Pennsylvania more than any other state is that there are only 2 penalties available for a juvenile found guilty of murder in the first, second, or third degree. The penalty for first or second degree murder, there is only one penalty, and that's life imprisonment without parole. Only if the person is found guilty of third degree murder is there a sentence that would be a term of years. So the problem ultimately is that if a juvenile is found guilty of first or second degree murder, because juveniles cannot be executed, they can only get a sentence of life without parole.
So when we consider the appropriateness of life without the possibility of parole for juveniles, I think it's important to look at the logic of the Supreme Court's decision in the juvenile death penalty case, in Roper versus Simmons, which was decided in 2005. And in that case, the majority opinion for the court made the argument that the death penalty is the worst possible punishment that we should reserve for the worst possible offenders. And because juveniles are more impulsive and less planful and more susceptible to peer pressure than adults, we should see them as less responsible for their behavior. And if they're less responsible for their behavior, then we should not expose them to the worst of the worst punishments. And I think now it's appropriate to ask whether the logic that was used in deciding that case can also be applied to parsing the appropriateness of the life without parole sentence for juveniles.
And the funny, ironic thing, of course, is that juveniles, because they start out at a younger age, would serve more time than an adult who also sentenced to life without parole for exactly the same crime. So the juvenile who's less culpable, let's say is 15 years old and lives to be the age of 70, would spend 60 years in prison, whereas an adult who's, let's say, is 25 when they commit exactly the same crime and also lives to 75 would only spend 50 years in prison. So the juvenile would spend 60, the adult would spend 50, and yet we'd all agree that a juvenile of a 15-year-old or a 14-year-old does not have the same judgment or ability to reflect on their actions as an adult, and consequently the same consequences should not follow. Ultimately, if there's going to be any change in the law regarding juvenile life without parole, it's only going to be because people have explained and demonstrated that that's what their beliefs are. And I think that the right answer in such a circumstance to lead to that change is for people to write letters to their legislatures, to write op-ed pieces in the newspapers, to participate in education sessions, to try to learn as much as they can about these issues, and to express loud and often the point of view that a juvenile life without parole is not a sentence that society should have.
What's most important for everybody to do is to share the information. Tell your friends about this. You know, if this issue concerns you, tell your parents and tell them, you know, this is something you care about. Ask them to contact their legislators. Contact, you know, your legislators. So you go online, and if you don't know who your state rep or your senator is, doesn't matter. You just stick your address in, and it'll tell you, or your zip code, and pulls it up. And most legislators have right on their sites where you can send an email directly, you know, send letters. College students can make such an impact too, because like I said, you know, they go home and educate their families, you know, educate their friends, and educate their teachers, you know, and so that's really what I think everyone can do.
If you pulled somebody off the street and said, you have to start a business, what are you going to start? 90% of the people will say either some sort of retail store or some sort of food business. You know, you have a lot of people who will have a lot of culinary knowledge, might have been cooking for their families for 30 years, and you know, great recipes, great ideas, great drive, but really have no way to access a commercial food market. Restaurant kitchens will cost $110,000, $120,000 just for the equipment, not to mention, you know, the rest of, you know, everything you have to do and renovation. So that's a huge barrier to entry.
The whole concept behind this kitchen incubator is that you know, catering is a common sort of entrepreneurial venture in the inner city. Folks will you know, cater parties for their friends, for their family, for their churches, and they'll do it out of their kitchens. And it's a very gray economy business. meaning that it's not a legitimate business because they're not in a health inspected kitchen, but at the same time they make good product and they have customers and they make money. Well, there's going to be a limit to how far you can go doing that out of your kitchen, or how much you can grow. I direct the Entrepreneurship Legal Clinic here at Penn, and what we do is we provide free transactional legal services to local entrepreneurs. Philadelphia generally is a city that has so much going for it, and yet has so much poverty and so many areas that really have seen a tremendous disinvestment.
The Enterprise Center Community Development Corporation, which focuses on the neighborhood immediately around our building here, and really works at sort of comprehensive community change. The corridor at 48th and Spruce was one of the sort of priority action areas. People really wanted to see change there.
48th and Spruce, when I talked to Gabriel about it, the idea was very good to me because I have some products that I like to develop and to also try to do retail marketing on some of my products, like the macaroni and cheese and stuff like that. Macaroni and cheese recipe, I've been working it for the past 15 years. And I just perfected it. It's one of my best sellers here. I have people come from out of state, New Jersey, Delaware, to come here and buy it. So I try to open up a market and see if there's an opportunity there.
Right. Why do you need to do it there instead of using this restaurant?
Well, here, first of all, space, and also I need the technical support because if I'm going to be mass producing, I need a kitchen space that will accommodate that, and I need the expertise. So by moving in that professional atmosphere, it will help me achieve my goal a lot better than doing it here while I'm cooking.
So they're taking what was a dormant property, they're turning that underutilized and actually not utilized asset and making it something for the neighborhood. It's going to be a place that is designed to help folks from the community. But the really cool part about it is that everything that they're going to do there is going to create more entrepreneurs.
So here we are in the former food right. A food entrepreneur would come to us, come to our door. They could be a caterer, they could be a baker, they could be somebody making a product for wholesale. They would come to us, we would say, great, you have to meet some minimum certifications, and once you meet those, then you're more than welcome to rent out the kitchen by the hour whenever you need it.
So one of the things that I really care about is encouraging folks that it doesn't matter how much money you have, it doesn't matter what neighborhood you're from, it doesn't matter what color you are, if you have a good business idea, you can compete.
The first film was done by Ann Onymous with help from Ms. Mouse. It's gotten 16,000 plus hits on YouTube. The second film was done by two second-year students who are now third-year students, one of whom is working on another project. And the final film was done by a third-year student and a second-year student. The version that you saw is the 5-minute version that we submitted to Mind TV, WYBE. We became members of Mind TV so as to have another outlet for our videos. They have a 5-minute format, so this is the 5-minute version, which I hope will be shown on Mind sometime soon. In addition to the videos, the students in last year's seminar produced a podcast, which we should be streaming soon, on domestic violence in Muslim communities. And if you go to our website, you will find on the Clemency Pardon, or the Clemency Video Project site, an interactive website on the Pennsylvania pardon process in which we pose questions and then provide video answers from a lawyer from Philadelphia's CLS. This year I'm teaching the VLA seminar in the fall, and so we presently have students working on 4 projects, 3 of which they came up with on their own. The topics that they're working on are gang injunctions, the Philadelphia foreclosure court, prison overcrowding in Philadelphia, and Lower Merion High School and the redistricting of Black South Ardmore. If you think that you could help the students working on any of these projects, please let me know. Slowly but surely, visual legal advocacy is finding a place at Penn Law School. We could not have gotten this far without project ideas and assistance from those of you who have attended roundtables in the past. So I want to thank you collectively for your past support and urge those of you who think that they have potential projects, clients, or causes that might benefit from a short 15-minute video or so to get in touch with us. You can get in touch with me by emailing me at raustin@law.upenn.edu or giving me a phone call at 215-898-5185. We also have lent our equipment to public interest organizations that have needed it. And if given a little time, we might even be able to supply a cinematographer to help you record an activity or an event that seems to warrant recording. Any questions about the videos that you've seen, or about what it is that we do as part of the Penn program on documentaries and the law? No questions? Oh, okay. Marianne.
I loved seeing these videos. I think they're fantastic. I wanted to ask, are the students that made these films here? Are the people that make the films here?
You mean in the room?
Yes.
No, I don't. Well, Ann Onymous is not in the jurisdiction.
Okay.
And
Well, I wanted to ask about the juvenile, the children that are behind bars. I mean, for me, I think it would be so amazing to see the kids or the people who were convicted as children to be able to speak on a film. And I know that that's probably very complicated, especially for a student. But can you work over the years to start developing a relationship with the prison system where you might be able to get some of the voices of the people in
we started working on that our first year. There is a Department of Corrections rule that says no one can record either audio or video, which is to say a lawyer cannot go in with a recording device to record an interview with a client. So there's a ban on recording in the Pennsylvania system, which would prevent us from recording people. There are exceptions. I just got a copy of the video that was done on the prisoners at Graterford interacting with community folks in connection with the mural arts program here. And they were permitted to go in to record the participants in that program. But no last names were allowed, and you could not see the prisoners' faces. You could see part of the prisoners' faces. You could never get the entire face. Of course, that was done with the support of the victims' advocates. So we've talked to the lifers about the possibility of getting permission to do some kind of filming, recognizing that we would have to get the support of the victims' advocates to do it. One of the students who are working on the prison overcrowding are talking to people who have recently been released or who have served time in the Philadelphia prisons. So we can do that. And we work closely with a group called ex-offenders for community empowerment, particularly around our pardon work. So we have 2 pardon videos, which I don't stream because they're too personal, really. So we do that. Steve?
Regina, is it clear that the Pennsylvania policy satisfies the First Amendment?
I've had students look into that, and the preliminary assessment that they made was that there was a colorable claim, but nobody has brought it. There is an innocence project out of Pittsburgh that comes from journalism that has thought about doing it, but nobody's brought the claim, and it's possible that we could do it. Radofsky said that at one point that he would be willing to litigate it, but the alternative is to try and negotiate with the prison authorities to get an exception.
And which is in their discretion.
Which is in their discretion. But if you want to work on a First Amendment case.
Well, I'm no First Amendment scholar, but when you mentioned the necessity of negotiating with the victim advocacy groups, that brings up the specter of viewpoint discrimination that I really don't like.
Well, the point of the rule arose, I thought it arose out of the controversy over Mamiya, but it didn't. There was some kind of a program that showed a prison band or rock group, which showed the faces of the prisoners, and the survivors of the victim of one or more of them saw that, and they were very upset by it, and that gave rise to the rule.
Well, I can't imagine that would satisfy a compelling state interest test if that's the appropriate test.
But it applies not only to broadcast, it applies to lawyers.
Right.
You can't take your recording device in. All you can have is a pen and a piece of paper, and if the pen runs out of ink, I think you're out of luck. Any other questions? Did you have a question? No? Going once? Going twice? Okay, we're going to give you a short break, and then we're going to start promptly at 10:30 with witnesses to hunger.